as well. So to ground our work today, I would like to acknowledge that at ONN, we are working on the traditional lands of the Huron-Wendat, Haudenosaunee, and the Mississauga of the Credit. This territory is part of the Dish with One Spoon, Wampum Belt, and the Upper Canada Treaties. I am also joining you from the traditional lands of the Huron-Wendat, Haudenosaunee, and the Mississaugas of the Credit. At ONN, we believe that as nonprofits, we must take seriously our role in responding to the Truth and Reconciliation Commission's calls to action. As settlers, we're grateful for the opportunity to live and work on this territory. As individuals, we all have an obligation to learn from Indigenous communities about collective ownership and sustainable economic and environmental systems that are respectful of the land and water on which we all depend. We encourage your organizations to read the 94 calls to action and plans for actions you will be accountable for. And joining me today is my colleague, Benjamin Miller, who is a policy advisor at ONN. He also works at Community Legal Education Ontario, CLEO, as a lawyer, where he focuses on nonprofit and charity law and policy. So now I'm going to pass it on to Benjamin, who will talk about the rules around election advocacy engagement.
Thanks so much, Candice. So it's my great pleasure and privilege today to speak to you about different legislation that governs the work of nonprofits as well as others in their election advocacy work. In particular, we're going to be talking about 3 pieces of legislation today. Number 1, the Income Tax Act as it relates to registered charities. So this isn't necessarily going to relate to everybody on the call. Only if you are a registered charity will this first section relate to you. Number 2, the Election Finances Act. This is the act that governs spending on advertising during elections, provincial elections. So not municipal, not federal, we'll be focusing on provincial elections and spending on advertising. And number 3, the Lobbyist Registration Act. This act governs paying either a staff or a contractor to influence a government decision maker, whether during an election or any other time. Now, disclaimer, as I'm a lawyer, and you know how lawyers are with our disclaimers. Today's webinar is intended to provide general guidance on matters of interest for personal use of attendees who accept full responsibility for its use. This is general legal information. It's not meant as legal advice. I'm not familiar with your situation in enough detail that I could provide you proper advice. So it's not meant as a substitute for legal counsel. So if you feel you need that, please seek that out. Before we jump into the details of this act, I want to build on the acknowledgement of the land my colleague gave by acknowledging the wisdom of one of the nations whose land we're on, to kind of center us with the ideals that all these legislations are trying to aspire to, so we can learn from the governance systems of, in this case, the Wendat people. So the Wendat people lived until the 1700s, when they were displaced by war in Wendake, what's now referred to as Huronia. And in this land, the way they organized their governance was through 8 matrilineal clans, each elected representatives to village councils, and there were 19 villages. Now, the interesting thing about these councils that I really want to drive home today is that anyone present can speak. So this was a radically egalitarian way of decision making that benefited from everybody present speaking, because ideally it takes the wisdom of crowds, it takes the wisdom such as is represented by nonprofits to contribute to decision making. So this is one of the great virtues of the Wendat approach to decision making. Beyond that, village chiefs, so these were chiefs from the councils that were elected per village, they would get together with the other villages, there were 19 villages, and decisions were made based on consensus and in a non-binding way. The key thing here is that it's not just that anybody present could speak, it's also that everybody speaking was doing so before everybody else. So not only was it radically egalitarian, it's also a radically transparent mode of governance. And the Wendat people continue these ideals in their governance today in and around Quebec City and elsewhere in Canada. The thing I want to drive home today for you is that while there may be administrative burdens associated with these acts, the goal is ultimately that we're aspiring to is for everybody to be able to speak. However, because we don't all meet in person, to create that sense of transparency, these legislations have been put in place to create public registers that people have to sign on to. What I would note is that transparency in the way of public registers is one level, but true transparency and accountability to our communities goes well beyond just signing up for the lobbyist registers or the election Ontario register. So as part of reconciliation and more broadly as strengthening our communities, it's very important to think about what does accountability and transparency in our advocacy mean towards our communities. So with that, I'll jump into the details of some of this legislation. Okay, so number one, the Income Tax Act. So again, this is the act that governs registered charities. So that's the kind of charity that can issue tax receipts. So the fundamental question is, what can and can't registered charities do? Well, I'm going to start by busting a myth. Charities can absolutely participate in elections. They can engage in election advertising, they can organize events, they can organize debates, so on and so forth. They can engage on social media. In fact, they can engage in unlimited nonpartisan public policy, dialogue, development, and activities. You may remember before 2018, there was what was called the 10% rule. This has since been replaced. So there's no quantitative limit on the amount of engagement charities, registered charities can do during or outside of elections when it comes to policy dialogue. There are two caveats here. Charities absolutely cannot engage in any partisan activities. Partisan here means communicating either for or against any party, leader, or candidate. So that means the engagement needs to be issue-based as opposed to partisan. The second caveat is that everything a registered charity does has to be in furtherance of its exclusively charitable purposes. So that means that when a charity gets involved in an issue, it's not just because its supporters want it to, or it decided, the staff decided it was a good idea. It's because they've made a decision that this would further the official stated purposes of the charity. And the purposes need to be charitable, and political purposes are not charitable. So relieving poverty, advancing education. There are many policies that can influence education. There are many policies that can influence poverty. Getting involved in those policies is acceptable. However, you cannot have the purpose of changing the law on poverty or changing the law on education. That can't be the purpose. It can only be a means to an end. So that's generally what I have to say on registered charities as kind of a preliminary point. Are there any questions at this time specifically about registered charities?
We have a question in the chat. Just to clarify what you've just gone through, does it apply to only charities or all nonprofits?
Only registered charities.
Thank you very much.
Okay. Hearing no further questions, and at the end of each of the three pieces of legislation, I'll be taking questions again, and we'll have a period at the end. So you will have an opportunity to ask, and I highly encourage you to do so because your questions make our information better, and it gives us a sense of where your priorities are at, what you're interested in. So now we come to the Election Finances Act. As I mentioned, this is the act that governs spending on advertising during or in a period before a provincial election. So it's not about municipal elections and it's not about federal elections. It's about spending money on advertising during and before provincial elections. So we're going to cover two questions. Firstly, whether you need to register as a third-party advertiser for the Elections Ontario Registry. And secondly, if you do need to register, what obligations, what are your do's and don'ts? So the general rule is as follows. If you are spending more than $500 on political advertising during an election period or a pre-election period, then you need to register. But that raises a bunch of sub-questions. What's political advertising? What's the election and pre-election period? And so on. So let's jump in to these four sub-questions. Number one, the first question you might want to ask yourself is, does your nonprofit or charity, so here it's talking about all nonprofits, not just charities, does your nonprofit or charity pay for advertising currently, or it plans to do advertising during a pre or during the election period? So it's not just about what you've already spent or what you're currently spending, it's also if you're planning to spend in future. So what counts as advertising for this purposes? This includes almost all mediums, but only if there are specific costs tied to the creation and dissemination. So that means posters, it means the side of buses, it means billboards, it means newspaper ads, it means blog posts if they're paid. It means any kind of medium could count as advertising. It's something that has to be published, but it could be any medium. So it's quite broad. However, it needs to be stuff that you're specifically spending money on. So that means you paid somebody to write it, or you paid somebody to design it, or you paid somebody for the space on the billboard. There needs to be some specific cost tied to the advertising. Now, there are some things that have been explicitly carved out from the Act, so will never count, even though they may fall into the broad heading of advertising. What are some of these exceptions? One, communicating with your members. So sending out a newsletter to your members would be carved out, but be careful here. Your members, it's not your email list, it's the members of your organization. And often, nonprofits send emails to people who aren't the members of your organization. How do you find out who the members are? Look at your bylaws and your governing documents. That will define who qualifies as a member. Communications with your members are never advertising for the purposes of the Election Finances Act. Get out the vote efforts. If you're just trying to get people to vote and you're not trying to get them to vote in a particular way or based on a particular issue, that is fine. That's not election advertising. Publication of a book not specifically timed to coincide with the election. So if you were working on a book or you were working on a report and you'd been working on it anyway, and it just so happens that it falls within this period, then as long as you can prove that, then that is carved out. Newspaper editorials or organized debates. So if it's an editorial, so not an advertorial, but something you're writing a letter to the editor, or you wrote something and you submitted to the Toronto Star, so they put it in the newspaper, that's carved out. If you're organizing a debate, similar, it's carved out. Okay, so you figured out, yes, we're planning to do some advertising. Next, you ask yourself, is it in the relevant period? So there are two regulated periods under the Election Finances Act. There's the election period, which takes place between the writ being dropped, so basically the official election starting, and the polling day, so the last day people vote. That's the election period. Then there's the non-election period. And that is basically, that's recently been expanded to a year before the election period. So for our purposes with the upcoming provincial election, we're looking at June 14th, 2021 to June 2nd, 2022. So that's the period in which you're thinking about your advertising. If you're advertising outside of that period, either before or after, it does not require registration. Number 3, is your current or planned advertising political advertising? So here's the general principle, because we can get lost in the details about does it count or doesn't it count. The general principle is this: are you trying to influence the outcome of the election? That is what's motivating Elections Ontario in how they judge, and it's very context based for them. They under the Act are entitled to look at all kinds of different factors to determine if your piece of advertising is political advertising. So it's very hard to give a black and white rules, but the general principle is: are you trying to influence the outcome? There are 2 types of political advertising, one more obvious than the other. So the first type is if it's advertising that promotes or opposes the election of a provincial party, candidate, or leader. That's obviously political advertising. And it could be explicit or it could be implicit in promoting the election of a provincial candidate, party, or leader. And the regulator can look at things like the color of your advertising, the language, and so on. If it mirrors a political party, that's something to be careful of. The other kind of political advertising is promoting or opposing an issue closely associated with provincial party candidate or leader. What does closely associated with mean? It's difficult and very contextual, but definitely if the party has made a big deal of the issue and you know it, if you started the advertising before you even knew it, the Elections Ontario has said they're going to be understanding. But the more a party emphasizes an issue as important to their election, the more closely associated it is with them. So there are lots of examples we could go through. For example, if you have an issue report card, like a policy report card of the different policies, what's the policy? How is it closely associated with one party over the others? In your report card, do you conclude by saying, and therefore you should vote for such and such, or do you strongly hint? Or do you just leave it at that? They've just been evaluated without any conclusion about what this means for a vote. Right? It's a spectrum of being more or less likely to be considered political advertising, and it's very contextual. But keep the broad principle in mind: are you trying to influence the outcome of the election? The fourth question, if you are engaged in political advertising, have you spent or will you spend more than $500 on political advertising? And this includes staff time, but it doesn't include web hosting. So remember what I said earlier: are you specifically incurring expenses tied to the production or the dissemination of the advertising? Your website that you have open all the time and you use it for all purposes, okay, so you also post some election advertising or some political advertising on it, but you would have spent that money anyway on the website because you use the website anyway. So that is not money that's specifically tied to a political advertising. We got the question in before this event: what about if I use a software? Let's say you purchase InDesign or something to do your election advertising. Well, it's contextual. If the reason you bought it, and this is documented in minutes and so on, the reason you bought it is for the purpose of improving your election campaign, well, then that would be considered a cost, likely would be considered a cost associated with political advertising. But if years ago you purchased this InDesign and you use it for other things, okay, so you also use it for political advertising. That's not a cost specifically associated with your political advertising. So the takeaway here is that anybody who spends more than $500 on political advertising during the election period or the period before the election needs to register. What's political advertising? You have to ask yourself the question: are we trying to influence the outcome of the election? What counts as the expense? You're asking yourself the question: is it specifically associated with the political advertising? So let's say you do need to register. What then? What are your do's and don'ts? Well, you do need to pass a board resolution authorizing political advertising expenses. The act doesn't say that you need to specify how much you're going to spend, but there needs to be an authorization. You could add that to the resolution if you want, but there does need to be some minimal resolution saying, yes, we are going to engage in political advertising expenses. Number two, you need to appoint a chief financial officer. This is not a term familiar to all nonprofits. It's a term used by the Election Finances Act, and it would be, I think, necessary to use the actual term. Somebody gets the title of chief financial officer. It's only for the purposes of Election Finances Act. They don't need to do anything else outside of the act just because they have that title. The chief financial officer is the person who's responsible for ensuring the organization complies with the Election Finances Act. And there are a few specific things they need to do. Firstly, they need to open a bank account. So this is a new bank account that is going to be used for all the eligible contributions. So these are money or resources that are given to you, and it includes goods and services. Obviously, you can't put goods and services in a bank account, but the money that you are given specifically for the purposes of political advertising needs to be put in a special bank account and tracked in that bank account. All the spending has to be, withdrawing from that bank account so that it's very easy to track. That's something the chief financial officer does. The chief financial officer deposits all eligible contributions in the bank account, and they keep track of the eligible contributions. They need to know who is giving the money, and I'll discuss why in a minute, why that is. And they need, in particular, to keep track of who is giving more than $100 of eligible contributions, because this is going to have to be publicly disclosed. So that's something to notify donors of. Organizations that register that spend more than $500 in political advertising during the period need to register with Elections Ontario as a third-party advertiser. They need to include in all political advertising on what's called an authorization statement. There's no specific wording that's prescribed, but it basically has to mean something like, this message brought to you by such and such nonprofit, or authorized by nonprofit XYZ. Finally, if a nonprofit or anybody is planning on spending more than $5,000, there's a requirement to appoint an auditor, and then they do an audit to ensure that the Election Finances Act has been complied with. That's what organizations that register do need to do. Here's what people aren't allowed to do. Organizations cannot exceed the spending limit. So this means you cannot spend more than $106,000 during the election period, and you cannot spend more than $637,000 in the pre-election period. So that's the year leading up to the election. Organizations cannot intentionally collude with other third parties to avoid the spending limits. And I want to be very clear here, because people could get the wrong message and say, oh no, we can't work together. That's absolutely not what's prohibited. Nonprofits are allowed to work together. ONN strongly encourages nonprofits to work together. There is strength in networks and coalitions and so on. What is prohibited under the Election Finances Act is working together intentionally for the purpose of escaping the spending limit and the other rules of the Election Finances Act, but most specifically the spending limit. Nonprofits are free to share information with each other. They're free to use the same vendor, which means like multiple nonprofits can post on Facebook. However, if there's evidence that they are coordinating their campaign for the purposes of exceeding a spending limit, that's where you run into issues. Nonprofits are not allowed to accept ineligible contributions. So these are contributions that people are not allowed to make to political advertising. So who cannot make a contribution to political advertising? Number one, charities are not allowed to give money to other people to engage in political advertising. As I said, they can do it themselves as long as it's not partisan, but they are not allowed to give money or resources, and that includes goods and services, to others so that they can do political advertising. Businesses and individuals who are not operating or resident in Ontario, so this is the, the fear of foreign donations thing, are not allowed to make contributions. So it's very important that nonprofits know who the donor is. If there are anonymous donors, it can be very problematic. And if a nonprofit runs into a situation where they cannot refuse or return a donation because they don't know who gave it to them, then that money or resources, goods or services, that has to be paid forward to Elections Ontario. Finally, nonprofits and others are not allowed to intentionally or unintentionally collude with political parties, candidates, or riding associations. So, it doesn't mean you can't meet with your MPP, but you cannot be planning your advertising alongside their advertising and taking your cues about what goes in your advertising from them, that kind of thing. So that brings us to the end of this section. Are there any questions about the Election Finances Act?
Yes, we have a lot of questions in the chat box. So the very first one, if you could just clarify if this act and info here specific, this section, is it specific to Ontario or is it for all provinces?
This is all Ontario. This is an Ontario legislation that applies to Ontario elections.
Okay, thank you. And we have a lot of questions regarding what is considered advertising, what is considered political advertising. So for example, does that mean we can't, what about social media? Does that mean we can't pay for Facebook ads?
So it's not that you can't. Again, it's not prohibitive. Remember the ideal I kind of set out at the beginning. Everybody can speak. It doesn't prohibit people from speaking unless they're going over their spending limit. It's whether or not you need to register. So it's about coupling that ability to speak with the transparency that's supposed to come with the Elections Ontario registry.
So would you have to register if you are paying for Facebook ads?
Yes, that could be political advertising, depending on the content. But yeah, that's eligible.
And another question is, what if a political party takes your campaign, but you were working on it first?
So the thing to keep in mind is that Elections Ontario is understanding about these kinds of situations, and they specifically address it in their handbook for CFOs. So by the way, if you want to look for more detail, you just Google Elections Ontario Handbook for Third-Party Advertisers. If when you developed it and sent it out, you had no way of knowing that it would become an issue closely associated with a candidate, and that candidate chose to make it closely associated with them, then Elections Ontario will take that into account in evaluating whether it counts towards your limit or not. But again, a lot of the stuff is contextual. If you had a good idea that it would be, it was already something of great interest to that party and so on, then, that's a good argument to say it was closely associated.
Yeah, we have a few more questions about the word closely associated, issue closely associated. So what if you have been advocating for a particular policy position starting before the pre-election period? Does staff time still count towards the $500 ad spending limit maximum, or would it be considered like just your general cost that you use all the time?
Right. So any cost that you incurred prior to the pre-election period, so that 12 months before the election, is fair game. It's not regulated. It's not covered by the Election Finances Act. So that's number one. The other thing to note is that if you are constantly advocating on an issue, right, unrelated to the election, you're just constantly advocating, and your advertising doesn't change because there's an election in town. It doesn't make reference to voting, doesn't make reference to parties and so on, right? It's the same kind of advertising you've always done. Then Elections Ontario has said they will take that into account and likely conclude that it's not elections advertising. However, if you are engaged in an issue all the time, and then as it gets closer to the election, your wording starts to change and it starts to be more directed towards, the parties, and you make reference to the votes and candidates and so on, even though you've been advocating on it all along, you've kind of redirected it, repurposed it specifically for the election, and then that there's a strong case that that becomes political advertising, election advertising.
But what if an organization that's always been working on the same issue, and during election or leading up to the election, they publish something like a one-pager where they highlight their priorities, but the content within the one-pager are not aligned with any party. Then, and then during the election period, a party publishes part of their platform that is the same as the other organizations ask. Would that be considered as closely association, or or should we pull our ask down off of our website?
Okay, so a couple of things here. So number one, just reminder of the caveat at the beginning: general legal information, not legal advice. You've given a very specific scenario. So number two, if the one pager just sets out the priorities, and remember, the general principle is, would it's maybe giving the specific wording of the statute would be helpful. An issue reasonably regarded to be closely associated with a candidate. Okay, so the elections on the act is set up in a way where the elections Ontario is supposed to use, like, common sense a bit to say, okay, we get it. You've been advocating all this time, and this is just another piece you're putting out. These are your priorities. From the context, it doesn't look like you're trying to influence the outcome of the election. It just looks like you're doing what you always do. If they could, with all the context in mind, reasonably come to that conclusion, then it isn't political advertising. However, if they come to the conclusion that, okay, so they made up this one pager before they had when they knew that it might be taken up by a party, then a party did in fact take it up, well, then they'll look at the full context and they'll say, it looks like this is part of a strategy to influence the outcome of the election. But what I want to absolutely emphasize is that does not necessarily mean you need to take down your asks. What it means is that you have to consider whether or not this counts towards an amount which would require you to register. If you don't want to register, well, then maybe taking it down. But if you've already incurred the expense, taking it down may not be helpful. If it counts as election advertising, it already has counted. But this bleeds into legal advice. And again, for specific situations, please consult legal counsel as appropriate.
We have another really good question. How can staff time be calculated if it falls under the regular duties of a salaried employee? Do we need to file interim reports every time we accumulate more than $1,000 in staff time for political advertising?
Right. So this is a great, really great question. So what happens is a final report is published at the end of the period. Basically, or sorry, when you first register, you file a report basically saying how much you're planning on spending. And then by the end of the period, or if you reach 5,000, when you reach 5,000, and then at the end of the period, you file a kind of final report taking account of all your spending, so on. How do you calculate staff time? So it's on a prorated basis, and this is one of the more onerous elements of the Election Finances Act. So if for 5 weeks, they're spending 10% of their time on the election advertising stuff, then you take their salary, you calculate what's 5 weeks out of their total salary, then you calculate what's 10% of that. So it's a prorated basis.
And maybe we have time for one final question, which is, do op-ed pieces that critique current government or current government policies fall under the carved out newspaper editorials or no?
Yes. Yeah, op-ed editorials of any kind, opinion editorials or otherwise, as long as they are not paid for, so really they're advertorials, they are carved out. And again, in this case, let's say you paid somebody to write it, but they wrote an editorial that was accepted by the newspaper for free as one of their articles, then it's in the carve-out.
Thank you very much. I know we didn't get a chance to go through all of the questions, and those are all really great questions. We'll make sure to keep those in the document, and Benjamin will answer those questions afterwards, and then we'll share the written documents with everyone.
Okay, so we come to the third act we'll be talking about today, third and final, the Lobbyist Registration Act. So the basic question here is, do you need to register as a lobbyist? And again, with the exception of a few activities, it's not that you're prohibited from lobbying, right? It adds enormous value to the public decision-making process that you may use a different word for it. You may call it, advocacy. It's just for the sake of the act that it's called lobbying. It's not a dirty word, getting involved, trying to influence decision makers so that they better meet the needs of your community. However, the law is set up in a way to ensure that there is some level of transparency to these activities. So it's not prohibited. It's just about whether you need to register and publicly disclose who you're talking to and what it is you're talking to them about. So who needs to register? Well, the basic question you need to ask yourself is, do you pay someone to lobby more than 50 hours? So payment includes both staff and contractors. Lobbying is the key term here. What does lobbying mean? Lobbying includes activities intended to influence a public office holder, another term I'll define in a second, with respect to changes to legislation, regulations, programs, privatization, and the awarding of grants, contributions, or financial benefits. So trying to influence a decision maker to get the grant awarded to you does fall into the category of lobbying. However, I'll talk a moment about what it doesn't include. Okay, so who's a public office holder? Because lobbying that's regulated by this act is only lobbying done to a public office holder. So who counts as that? Public office holders include ministers and their office and people who work in their office, MPPs and people who work in their office, and directors, officers, and employees of certain public agencies. So this would be like Ontario Power Generation and so on. So the key thing here is that there are lots of public servants who you may talk with on a regular basis who do not fall into this category. What does lobbying not include? So just like Elections Finances Act had carve-outs from advertising, the Lobbyist Registration Act has carve-outs from lobbying. Lobbying does not include public submissions to Parliament. Again, the ideal here is transparency, but if it's a public submission to Parliament, there is already that transparency, so you don't need to worry. Individual client advocacy. So let's say, somebody's having trouble getting their passport, or somebody's having trouble accessing social assistance, or somebody's having difficulties with the with the Canada Revenue Agency and so on. All that kind of individual advocacy that you may do on behalf of your clients does not count as lobbying. Public consultations. So this is where the government's saying, okay, we're considering passing a law, we're inviting comments. If you respond to that and say, okay, here's our submission, that does not count as lobbying, that's carved out. If you go and request for an interpretation of the law or an interpretation of regulation and so on, basically, so let's say an agency or a ministry puts out a call for tender or a grant proposal form, and you're worried about calling them because you're like, oh no, could that be lobbying? Well, no. If you're just calling them to say, oh, we have this question about it and that question about it, well, that's perfectly fine. It's where you're trying to influence the decision, where you're trying to influence how the grant is structured and so on, that it gets into the lobbying territory. So if you need to register, what do you have to do? What are you not allowed to do? So if you hire somebody, so an outside person who was a consultant, so they're a contractor for you, they don't work for you, they have to make their own filing. They have to register and provide information on who paid them. So that means they would, and it's above $750, right? For a minimum, and I should say, I forgot to mention this on the last slide, but a minimum of 50 hours. Once you cross the 50 hours threshold, that's when it gets into lobbying that requires you to register. so if they do more than 50 hours of lobbying collectively, so it might be that they have multiple clients and you're only one of their clients, but if they do more than 50 hours of lobbying, they have to register, and they have to include who they're paid by to do the lobbying for more than $750. So that might include you. Organizations with in-house lobbyists. So this is where the staff yourself within your organization are doing the lobbying. So they need to create a profile, and the senior officer in your organization is the person who holds the account, and they have to provide information about what they lobbied about to whom. So it's the same thing as the consultant lobbyist. This, once you register, you need to keep this up to date. So if you're engaged in more lobbying within 30 days, you have to report that you engaged in more lobbying, who you talked to, what you talked about. So, it could be a bit annoying to constantly have to update the lobbyist registration, but there you go. It's kind of you have a 30-day time period. What aren't you allowed to do? Number one, there are certain broader public sector organizations. So these are organizations that receive more than $10 million in funding from the government that are prohibited from lobbying outright. So think hospitals, universities, etc. I am by no means an expert in that, and you can look at the regulations that list specific organizations who fall into this category. It does not apply to most nonprofits. Everybody is prohibited from paying lobbyists on a contingency fee basis. So if you say, well, look, if you get us that grant, you get 10% of what we get, that's prohibited outright. That's not, you can't pay lobbyists on contingency fee. And thirdly, it is prohibited to hire a lobbyist who is being paid to advise the government on the same issue. So this may be something that a nonprofit want to ask, especially if they're retaining somebody who's high profile or an expert in the area, where the expert may be paid by government to advise. You may wish to ask and ensure that they are not being paid to advise on the same issue to government. So that's the summary of the Lobbyist Registration Act. Are there any questions about that?
Maybe just some clarification. Is this also just apply to Ontario?
Correct. This is in Ontario. Right. Yeah, I should have mentioned that. So municipalities have their own rules. The federal government has its own rules about lobbyist registration, and they have separate registries.
And when we talk about 50 hours, is it 50 hours a year?
Correct.
I think that's all the questions we have. So this rule doesn't include municipal leaders then, because it's only on the provincial level.
That's right.
Okay. I think that's all the questions we have in the chat box. Okay, we have more questions. So if you're advocating on one issue like poverty, then are you considered a lobbyist?
So it's not an individual issue, it's an individual person. So if you have a client who is on social assistance, for example, and they're having trouble accessing their benefits, or they're being, over scrutinized by the government, or whatever it is, and so they come to you and you say, okay, we're going to call OW on your behalf. That's individual advocacy that is carved out. Single issue advocacy absolutely can count as lobbying.
Mm.
It all depends. Are you specifically trying to influence a decision maker that falls into one of the categories I mentioned?
Okay. And so does the 50 hours per year relate to election or non-election periods, or 50 hours per year regardless of if an election is happening?
It's regardless. So the Election Act is one thing. The Lobbyist Registration Act is another thing. The Election Act only applies in and around elections. The Lobbyist Registration Act applies all the time.
Okay. Thank you very much. I know we have like a few other questions too, but as we've mentioned before, we'll document all the questions. So please continue putting your questions in the chat, and then we will document those and answer those and share the written document with everybody afterwards. Thank you, Benjamin, very much for walking us through some of the election advocacy, some of the rules around election advocacy engagement. It is definitely very important for nonprofits to understand the rules around what they can and cannot do. Oh, yeah. can and cannot do, so that organizations can engage in election advocacy with more confidence. So now, talking about election advocacy, I would like to invite everyone to think about this question. What comes to mind when you hear the term advocate? Who or what are you picturing? So are you picturing maybe like someone who's leading or participating in the protest, or people whose job titles have the word lobbyist or advocacy? What about someone who is really passionate about something like recycling and the environment, and they're just spreading the word to their friends and their community about the importance of recycling and how to do it properly? Or what about someone who's organizing a food drive to collect food donations? Do you think of yourself or do you think of yourself as an advocate, or do you think your organization is currently engaging in advocacy work? Just something to think about, and we're going to come back to this question later. So yeah, nonprofits play a very important role in inclusive democracy. And why is that? So as nonprofits, we're usually the bridge between our communities and the government. A lot of us are doing some frontline work, working with communities day to day, so we understand the issues affecting our communities the best. We are in a position to engage and amplify community voices, and also to provide unique public policy insight. We're also in a position to hold governments and decision makers accountable. We know what is happening on the ground. We have strong local infrastructures, and usually nonprofits are trusted leaders in communities. So why does advocacy matter for nonprofit organizations? So first of all, public policy impacts nonprofits. It affects the way nonprofits do their work, how they operate, what they can and cannot do. It also helps nonprofits meet their mission. So a lot of times the issues that nonprofits work on require systemic changes in order to address the underlying causes. Also, political parties and candidates during elections will be talking about issues nonprofits are already working on, such as childcare, affordable housing, decent work, climate change, diversity and inclusion, truth and reconciliation, and more. And those issues all impact the communities that we serve. So now going back to kind of like the question that I asked at the very beginning, advocacy actually comes in many forms. And I know the words like democracy and advocacy sometimes can feel like such big words and can sound intimidating, but oftentimes we are already doing advocacy work, whether we call it that or not. So for example, a lot of us create resources or share and communicate the mission of our organization to others. That is a form of advocacy. And also, often nonprofits connect with each other to work together on a similar or complementary issue. That is also the core of advocacy, when organizations and individuals work together to move the mission forward. Some other examples, like meeting with candidates or even amplify existing community initiatives, those are also some examples of advocacy. So everything that we've covered so far, including the election advocacy engagement rules, as well as the importance of advocacy and how to communicate the value of the Ontario's nonprofit sector, they're all included in ON's newly updated election advocacy toolkit. This year, our advocacy toolkit is bilingual, both in English and French. It also contains sections on tips for successful advocacy, community engagement, some different tactics to engage in election advocacy, also how to engage through traditional and social media. And by traditional media, we mean like example includes op-eds, where folks were asking about earlier, but also some tips on how to keep engaging and amplifying your voices after the election. It also includes a lot of infographics that can be useful for the sector. For example, we just updated an infographic on Ontario's nonprofit sector based on the 2019 StatsCan data. And it can be very useful to utilize this infographic simply to showcase the impact of nonprofit sector within Ontario, to showcase that our sector is a large driver of economic and social development, where employers, we offer lots of job opportunities. We mobilize volunteers to keep them engaged and connected. Next slide, please. And within the election advocacy toolkit, I also want to highlight that in the end, we offer a list of different resources. Those include maybe other election advocacy toolkits created by other organizations, or some interesting articles that might be really helpful, as well as some guides on how to create your media engagement strategy, how to use different social media tools to engage your community. And we've categorized them based on their content to help folks access or look for the information they need more easily. So yeah, in the end, I just want to say that nonprofits, by our very existence, we're trying to make the world and our society a better place and to help our communities. And that in itself is a true form of advocacy. So we really encourage folks to use the upcoming election as an opportunity to share the impact you're having, to talk about the issues your nonprofit and community care about. Let's not be humble. Yeah, so know the rules, get involved, and spread the word. That's all, and we will launch our election advocacy toolkit that I mentioned before early next week. So yeah, that was like a preview of all the content that's going to be included in the toolkit, and early next week we'll officially launch the toolkit, and we'll email that to everyone, and you will also be able to access that on ONN's website. So in the end, want to see if anybody has any questions regarding the election advocacy toolkit. See more questions popping in the chat regarding the rules. Yes, please keep your questions coming. We will be more than glad to collect all of your questions. Okay, well, then thank you everyone so much for joining us today. We hope that you found this webinar to be helpful and useful. As we've mentioned earlier, we will email you the presentation slides, the recording of this session, the links to some key resources, as well as our election advocacy toolkit. Also a document with all of the questions from the chat with answers. And we'll do that within a week following this webinar. Also, we're hosting another webinar next week on February 17th at 1 p.m., which will focus on how to engage communities in election advocacy. And we hope to see you there. And finally, whether it's connecting over social media or joining our future webinars or becoming an ONN member, we hope that you keep in touch. And that's all for today's session. Take care and have a good afternoon, everybody. Thank you.